If your employer is filing your H-1B petition right now, stop everything for just a few minutes. USCIS has just made a critical change that affects every single H-1B petition being filed this season. If you or your employer use the wrong form, your entire petition will be rejected. Not delayed. Rejected. This is not a small update. This is one of the biggest changes to the H-1B filing process in years. So stay with me, because the next few minutes could save your work authorization. Welcome back to Immigration Updates today. We break down immigration news in simple, honest language, so you always know exactly what is happening and what you need to do. Today we are covering a major update from USCIS, the United States Citizenship and Immigration Services. As of April 1st, 2026, USCIS is now requiring all H-1B petitions to be filed on a brand new version of Form I-129. The old form is no longer accepted. Period. This change came into effect just this month, right at the start of the fiscal year 2027 H-1B cap filing season. If your employer has already started preparing your petition, they must check which version of the form they are using. And if your company's HR team or attorney has not already updated their forms, this video is for them too. So let us go through everything. What changed, why it matters, who is affected, and what you need to do right now. Form I-129 is the official petition that U.S. employers file with USCIS to sponsor a foreign worker for a non-immigrant visa. It is used for many visa types, including H-1B, L-1, O-1, and others. USCIS published a new edition of this form on February 27, 2026. This updated version is dated 02/27/26 at the bottom of the form. Starting April 1, 2026, this is the only version USCIS will accept. The previous version of the form, dated January 20, 2025, is now completely rejected if received on or after April 1st, not returned for correction, not given extra time. Rejected outright. So, what should you do right now? Ask your employer or immigration attorney to confirm they are using the February 27, 2026 edition of Form I-129. Look at the bottom of the form. The edition date must say 02/27/26. If it does not, do not submit. Now let us talk about what actually changed inside the form, because this is not just a formatting update. There are real new questions that employers must now answer. The biggest changes are in the H-1B data collection supplement section. Specifically, questions 7 through 11 are new or significantly expanded. Employers are now required to share the following information about the H-1B position: the minimum education required for the role, the specific field of study required, the minimum years of experience needed, whether the role involves supervisory duties, and if so, how many people the employee will supervise, and any special skills or certifications required for the job. For CAP subject H-1B filings, employers must also identify the Standard Occupational Classification Code, known as the SOCI code, and the wage level that was used during the H-1B lottery registration in March 2026. Now, here is where things get very important. Starting with the fiscal year 2027 H-1B cap season, USCIS introduced a wage-weighted lottery system. This is a major shift from the old random lottery. Under the old system, every registered applicant had an equal chance of being selected. Under the new system, registrations are assigned weighted entries based on the Department of Labor wage level for the position. Higher wage levels receive more entries in the lottery. Wage levels go from level 1, which is entry level, all the way to level 4, which is senior or expert level. A level 4 position can receive up to 4 times the lottery entries compared to a level 1 position. This change was designed to prioritize higher-paying, more complex roles. Now here is where the new Form I-129 connects directly to this system. Because employers provided a wage level at the registration stage in March, USCIS will now compare that wage level to what is stated in the final petition and the labor condition application, also called the LCA, from the Department of Labor. If there is any mismatch between what was claimed during registration and what is stated in the actual petition, USCIS will take action. That action could be a request for evidence or it could be an outright denial. This is one of the most important parts, so please pay close attention. USCIS will now compare three things: the wage level and SOC code used during lottery registration, the information on the certified LCA from the Department of Labor, and the details provided on the new Form I-129. All three must be consistent. If your employer stated during registration that a role is a Level 3 position, then the final petition must also reflect a Level 3 position. It cannot be downgraded to Level 2 in the final filing. Here is a practical example. Suppose a company registered a software developer position at a Level 3 wage during the lottery to increase the chances of selection. But when filing the actual petition, they describe a role that only requires a bachelor's degree and 1 year of experience, which typically matches a Level 1 or Level 2 wage. USCIS will notice that inconsistency immediately. That petition is likely to receive a request for evidence or be denied. The new form makes these inconsistencies visible in a way the old form never did. Every answer must be accurate, consistent, and supported by documentation. While we are on this topic, there are two more updates you need to know. First, the filing deadline. If your registration was selected in the March 2026 lottery, your employer has a 90-day filing window that opened on April 1, 2026. This means the expected deadline to file your petition is around June 30, 2026. USCIS does not grant extensions for late filings. If you miss this window, you lose your H-1B opportunity for this fiscal year. Second, premium processing fees have increased. As of March 1, 2026, the fee rose from $2,805 to $2,965. Premium processing guarantees a USCIS decision within 15 business days. Also important, USCIS no longer accepts paper checks. All payments must now be made electronically. Let us turn all of this into clear steps. If you are an H-1B worker waiting on your petition, talk to your employer or HR team today. Ask them to confirm they are using the new form, edition, February 27, 2026. Ask about your petition timeline and make sure your employer is actively working on filing before the June 30th deadline. If you are an employer or HR professional, do not use the old form. Download the new edition directly from the official USCIS website. Review your LCA carefully. The wage level, the SOC code, and the job duties on the LCA must all match what you stated at registration and what you will state on the new form. Document everything. And if you filed the H-1B registration without an attorney, strongly consider bringing in legal counsel for the petition stage. Let us quickly summarize everything we covered today. USCIS released a new edition of Form I-129, dated February 27, 2026. This form became mandatory on April 1, 2026. The old form is rejected if received after that date. The new form now requires detailed information about job requirements, including minimum education, field of study, experience, supervisory duties, and special skills. This change is directly connected to the new wage-weighted H-1B lottery system for fiscal year 2027, where higher wage levels improve lottery odds. USCIS is now comparing registration details against the final petition and LCA to catch inconsistencies. Any mismatch can result in a request for evidence or a denial. The filing deadline for selected petitions is approximately June 30, 2026. Premium processing now costs $2,965, and paper checks are no longer accepted. That is everything you need to know about this update. Staying informed is your best protection. If this video helped you, please hit the like button. It helps more people in the same situation find this content. If you know someone going through the H-1B process right now, share this video with them. This information could genuinely make a difference in their case. And if you have not subscribed yet, please do. We publish regular updates on H-1B news, green card changes, USCIS policy shifts, and travel and visa rules. Thank you for watching Immigration Updates today. Stay informed, stay prepared, and we will see you in the next video.